Due Process, recipient of 5 Mid-Atlantic Emmy Awards since 1997.
You have the right to remain silent.
For 34 years, it's been the law, but Miranda warnings could be on their way out. The U.S. Supreme Court is about to decide.
I think this policy is hateful and hurtful and damaging.
And if you thought this fight was over, think again. The case of the gay Boy Scout is headed for its final showdown. A Supreme Court update up next on Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual.
It's the place where the really thorny issues get argued and judged, the ultimate arbiter of what is constitutional and what is not. I'm Raymond Brown, and on our docket for this due process, the United States Supreme Court.
And I'm Sandra King. In the next few months, the High Court will be hitting the tough ones, from so-called partial birth abortion to New Jersey's hate crimes law, from HMOs and patient rights to the rights of violent sex offenders.
But on this edition, we focus on 2 of the cases on this year's court calendar. One began right here in New Jersey with an Eagle Scout who was banned from the Boy Scouts for being gay.
The other could impact nearly every arrest in every state, depending on how the court calls Miranda, that requisite reading of rights that we know so well from all those arrests and all those movies and on TV.
240-20 sub 7 is unconstitutionally vague and will never survive an appeal.
You probably already know you have the right to remain silent. Why don't you use it?
And after 34 years of Miranda and countless TV and movie arrests, don't we all know the routine?
You're under arrest for the murder of Jennifer Gordon.
You have the right to remain silent. Anything you do say can and will be used against you in a court of law.
We may not know the name Ernesto Miranda, whose conviction for kidnapping and rape was overturned by the Warren Court on the basis of a coerced confession without a lawyer present.
In a pardon attorney, we will provide you with the dumbest lawyer on earth.
But we do know the warning that bears Miranda's name, a warning that will next month be back before the court for the first time in more than 3 decades. 3 decades in which the words, "You have the right to remain silent," have become among the best known in the language.
You have the right to remain silent.
I wanted to show myself it last night. He kept trying to talk me out of it.
Don't say anything. You get a lawyer.
Shot him and I'd shoot him again.
Really? I really think that you should talk to a lawyer.
The Miranda case didn't create the right to a counsel, didn't create the right to remain silent, simply required that it be told to the suspect. And then he could choose either to remain silent, knowing that he had that right, or he could in fact waive that right if he did it knowingly and voluntarily.
And you really need an attorney, Blake. Hey, have you waived your right to counsel?
Yes, I want to be any help I can in solving Walter's disappearance.
Blake, if I can just... You heard it, counselor. Let's go.
On the TV cop shows, the warnings usually played straight, going all the way back to Dragnet.
If you so desire and cannot afford one, an attorney will be appointed for you without charge before questioning. Now, do you understand that?
I think the danger is that some police still feel that it's simply a procedure that they have to get through. Then they maneuver the person to waive those rights that he's been told about, and then they end up getting the same confession.
You got no right talking about my sister.
Whoa. You want to speak with us? Your attorney must be present and in agreement that you waived your Miranda rights.
And sometimes the more cynical TV cops simply say, "To hell with Miranda."
You have nowhere to go in your interrogation strategy other than physical force, at which point I'm immediately going to demand counsel. Which you assume that I am going to run right out and get you instead of smacking you in the face.
That, of course, can have its consequences.
Hey,
In
guys,
fact,
I told you shut up with that old sad story. We don't buy it.
and on TV.
We need to move to suppress McPhee's statement. It's inadmissible. Being a minor, he should have had me with him. He wasn't properly Mirandized. They took advantage of his naivete.
There's been no real good empirical studies on how many people have been freed because of the police failure to give the Miranda warnings.
But if you wonder why Miranda was established in the first place,
Fred, you're under arrest for grand theft and forgery.
you might talk to those who are fighting to keep it.
And I believe that it's a mistake to turn the clock back some 30 years and return to a standard that we already determined was woefully inadequate.
Or you might just go to the movies.
Would you be willing to beat a confession out of a suspect you knew to be guilty?
No.
Would you be willing to shoot a hardened criminal in the back in order to offset the chance that some lawyer...
No.
Then, for the love of God, don't be a detective.
So Miranda's on the line, but will it survive? And will it matter? We'll be asking Frank Askin, Rutgers Law School professor and constitutional law expert, what he thinks.
But first, we go to Newark and criminal defense lawyer Mark Winkler, who argued a Miranda case and won a reversal for a 13-year-old accused of arson. Mark, good to have you with us. Tell us how Miranda arose in the context of your case.
In our case, we had a 13-year-old juvenile who became a suspect in an arson case in Bergen County. The police went and picked up the child's mother, then they went and picked up the child from school. They brought him to the Bergen County prosecutor's office, took him into the arson squad. They gave the mother a brief advisal that she was consenting to have them speak to the child. They did not tell her that they were going to speak to the child without her present. Then they left the mother out in the waiting area behind a locked door, took the child in, and they grilled him for about 70 minutes till they got the statement they were looking for. During that time, they did not advise him of his Miranda rights. After they got a statement that they found satisfactory for inculpating him in the crime, they went back, brought the mother in, and then had the child repeat to the mother the incriminating statements they had just gotten out of him. At that point, they finally did Miranda, brought the mother back, transcribed the whole statement, and had what they were looking for. So in our case, it went up to the appellate division. They concluded that the child should have had Miranda rights, and they also concluded that the whole totality of the circumstances, what they did with this child, rendered the statement involuntary and inadmissible. So that's, in a nutshell, what took place in our case. And Miranda was important to protect this child's rights.
Frank Askin, I think maybe we have a notion of what Miranda is. If we watch TV, right, we certainly see it all the time. I think what may be confusing some of us is how is this principle that was founded in 1966 or established by the court in 1966 by the Warren Court, by Earl Warren himself writing the opinion. 34 years later, we have an attempt to dash it based on something that happened in 1968 in the Congress. Explain this to us.
Well, what happened was about 2 years after the Supreme Court decided Miranda, Congress decided to overrule Miranda. Frankly, nobody ever took it. I mean, they did overrule Miranda, but nobody ever took it seriously.
So why? We've had 7 administrations, Republican and Democrat. Nobody has ever tried to get rid of Miranda.
The prosecutors, first of all, have recognized that Congress couldn't overrule Miranda. It was a constitutional ruling. So they've ignored it. They haven't attempted to enforce it. And I must tell you, in the meantime, I think the police and prosecutors have gotten come to learn how to live with Miranda. They don't care anymore. In fact, I think it's now an issue that's really, the time has come and gone.
But Frank, if that's true, why is there essentially an ideological assault underway? Because supporting this appeal have been a number of groups, public interest groups, I think it's fair to say conservative, that really think this is an issue that they need to bring and argue in front of the United States Supreme Court.
Well, there are still these conservative groups who like to think that the Supreme Court is somehow too soft on crime, although that's probably a dead issue now. And they would like to try to re-emphasize congressional ability to overrule Supreme Court decisions that they don't like. So there's this one law professor out in either Utah or Colorado who's been pushing this issue for 25 years, that Miranda really wasn't based on constitutional ruling. It was sort of a policy ruling by the Supreme Court, and that Congress could overrule it. I don't think anybody takes them terribly seriously. I don't think there are 5 votes on the U.S. Supreme Court that are going to go along with that. And I don't think anybody, other than a few fanatics on the right, really care very much anymore.
Well, first of all, we did have a federal appellate court say, yes, agreed, right?
The Fourth Circuit, where they have concentrated all the conservative jurists in the country on the Fourth Circuit.
And we did, for at least a minute, have the Justice Department in there. We had a U.S. attorney who was obviously with that position. Now we know that Janet Reno herself has signed and said that she does not want to be a part of any action to do away with Miranda. But you're so sure that this court, a more conservative court than the Warren Court, which was itself split, is going to say, yes, hold on to Miranda?
I think there are only 3 votes at the most to overrule Miranda. And Justice Kennedy, I think, made it pretty clear. They need Kennedy. If there's going to be a majority over Miranda, Kennedy's vote is needed. He wrote an opinion a year or 2 ago in a case out of Mississippi, which indicated he's very happy with Miranda. He thinks Miranda plays an important and appropriate role.
Frank, I like Miranda. I hesitate to disagree with you, but I think you're wrong in your prediction on this one. Let me bring Mark Winkler back into the conversation. Mark, I'm sure there must be occasions when people, either learning about this juvenile case you handled or others like it, say, isn't this just a technicality, this concept of having to give people rights before a statement can be used against them? How do you respond when people ask you, well, isn't this just a technicality and some way that you clever, slick defense lawyers find to get guilty people on the street?
That sometimes is the public perception, but it really is a misperception because obviously it's not a technicality, it's the fundamental part of the Constitution. If we say that people have a right against self-incrimination, but we don't create a remedy, some mechanism to enforce it, that right evaporates. As Professor Askin was saying, you know, there is some conservative opposition to Miranda, and it has been for a long time, but it really is ill-founded. When I first practiced law, I practiced in the military, one of the more conservative jurisdictions you could have, and they have a Miranda rule that's even more sweeping than in the civilian sphere, and it works for them. So if it can work in that context, I see no reason for it to even be challenged at all in the civilian context.
But Mark, you know that when Raymond talks about a technicality, he isn't talking about whether or not this is based in good constitutional law, but rather the public perception that there is guilt, there is innocence, and then there is some kind of stuff that they don't understand that goes on at the legal level that lets guilty people walk, and Miranda often is the name they'd put on it.
That is often the public perception, and often the public perception is wrong, because also it protects innocent people too. I think in the juvenile context that's especially apparent because when we step back we can look at a juvenile and say they really are more susceptible to coercion and being compelled to give statements that aren't true.
I'll bet you I can get you and Frank to agree with me on one aspect of the possible peril for Miranda, and that is, I'll bet a majority of the population, if it were given a vote on whether Miranda would stay in or not, would toss it out, in part because you think maybe people don't understand what the Fifth Amendment's all about?
I think that's probably true. Yeah. But there's another piece to this, though. You know, Miranda was really initially, the urgency behind it was that the Supreme Court was tired of courts deciding in every case whether a confession was voluntary or not. And they needed a prophylactic rule. Otherwise, they were, case after case, the issue that whether confessions were voluntary. That was the issue.
But Mark,
now
don't you still go
much easier now with whether they were given their warnings or not.
Mark, as we run out of time, let me ask you this. Don't you still go into courts and argue that a statement is not voluntary, even if you don't think you have a Miranda issue to raise?
On occasion, you do make that argument. And I think part of what people need to recognize is that the cases where a confession is thrown out based on Miranda make the newspapers because they are out of the ordinary.
But Frank, Professor Cassell from Utah, whom you refer to, let me take his position for a moment, since there doesn't seem to be anybody else here who's taking it. And that is that we're not arguing against throwing out protections supplied by the Fifth Amendment. We believe in voluntary. Voluntary is what's required. Voluntary is what's in the law passed in 1968. We want to go back to the voluntary standard. What do we need all of this for?
Well, again, it is a prophylactic rule. It is much easier for a court to decide whether or not a victim was told of his or her rights and then made a knowing confession, because if he didn't know of his rights, involuntariness inevitably gets into every case.
Frank, isn't this also an extension, though, of the concept in that the court said, look, just being alone in a station house can be coercive?
Absolutely. That's right. So that's why they get their warning, and then we sort of taken care of most of the problem.
Last time I'll ever bet against you, Frank, but I'm betting this case is in more trouble than you.
Okay,
you're going to stay with us. Mark, you're going to have to leave. I want to thank you. Sandy, of course, you're staying. And when we come back, we're going to revisit the question of the Boy Scouts' right to ban gays, so stay with us.
So you may have thought it was all decided. After all, the state Supreme Court had its say. It said the Scouts could not keep gays out.
The case was James Dale versus the Boy Scouts of America, a case we covered in this report last season.
James Dale is 28 years old. He works at Paz Magazine. He joined the Cub Scouts when he was 8 and devoted 12 years of his life to the organization, rising through the ranks to Eagle Scout and then Assistant Scoutmaster.
I was very involved in the program. It was really something that was very important to me growing up.
So it came as a great surprise when he received a letter one day stating that he had been summarily dismissed.
I was speaking at a conference on the needs of lesbian and gay adolescents at Rutgers University in my capacity of co-president of the gay group there.
A Star Ledger reporter was there. The story appeared the next day, with James' picture prominently featured. Less than 2 weeks later, he was out of the Scouts.
I was expelled at 3 different levels, and each time they said that you're entitled to appeal this decision by a panel of your peers. 3 times they said, I want to sort of present my case, and 3 times they said, basically, we had the meetings, you weren't invited because you're gay, and it's really a moot point.
Determined to have his day in court, James appealed to Evan Wolfson of Lambda Legal Defense, a national organization devoted to upholding the civil rights of gays.
We filed the case, of course, in the lower court. The Boy Scouts succeeded in having it transferred to the Chancery Court in front of a judge named Judge McGann. He ruled against us. We appealed that decision to the Appellate Division.
The Appellate Division reversed the lower court, invoking the New Jersey law against discrimination. The Boy Scouts argued that they were not a place of public accommodation, rather that a Boy Scout troop is a group of boys who are members of a club. They took the case to the New Jersey Supreme Court. The Boy Scouts of America are caught in a societal conundrum. Scout leaders see homosexuality as morally objectionable. The American public is somewhat ambivalent about gays, preferring, like the military, a don't ask, don't tell approach. Boy Scouting has followed the same line. The problem for James Dale was that his gayness became public.
The Boy Scouts, they taught you to stand up for what you believe in, to stand up for what's right, and that you know what's right, and sometimes your peers might not agree with you, but you know down deep inside, and that's definitely the situation here.
But the Scouts claim that what Dale is doing violates their First Amendment rights. If they're forced to take Dale back despite his opposition to their anti-homosexual policy, their rights as an organization would be infringed.
I think this policy is hateful and hurtful and damaging to a lot of kids out there, and it's teaching them the wrong thing. So I know ultimately that the policy is going to be changed, and hopefully either I can benefit out of that or other people can benefit out of that.
And Dale did win his case in the state Supreme Court, but it didn't end there. The Boy Scouts appealed in federal court, and the High Court agreed to decide the case.
And both sides think there's a lot at stake. The Boy Scouts say it's their right as a private group to restrict membership based on what they say are moral values. Meanwhile, gay rights advocates see the Dale decision as a major gain in an ongoing struggle, one they're counting on holding on to. We'll be talking to Scott Pusillo, another gay Scoutmaster here in New Jersey. But first, let me turn to Professor Frank Askin and ask you, if the state Supreme Court decided that the law against discrimination means the Boy Scouts have to keep Dale on as a Scoutmaster, what issue are the Boy Scouts raising as they go to the United States Supreme Court?
Well, the Boy Scouts claim the New Jersey ruling violates their rights under the First Amendment of the U.S. Constitution to freedom of association and freedom of expression. So the question is really, is this a discrimination case or is it a free speech, free association case?
In a sense, they're saying they have a right not to associate with James Dale?
That is correct. And they claim their federal First Amendment rights trump New Jersey's law against discrimination.
Scott, we know that you don't agree with the Boy Scouts' position on that, but let me ask you first about your own situation. You are a gay Scout leader here in New Jersey. Some people might be surprised that you are not having a problem, or are you?
Actually, I'm not having a problem. My troop really has not made an issue of it. It was brought to discussion at one committee meeting, and none of the adult leaders in the troop seem to have a problem with it. I have not received a letter from Monmouth Council. I am a leader in a Scout troop not far from where James Dale was. So I have not received a letter from the council stating that I am ineligible to be a leader. in the Boy Scouts of America, and I'm not sure whether they're waiting for the Supreme Court decision or whether they realize that they're wrong, that gay leaders do have a lot to give back to the organization.
And you're not only continuing as a Scout leader, but you're also out there advocating full open membership in the Boy Scouts for gays, and I think also for atheists and for girls.
Correct. I'm with an organization called Scouting for All. We're based in California, and we're currently running a petition drive to collect signatures of petition against the Boy Scouts of America's discriminatory policies against gays, atheists, and women, because we feel that it's just not the type of moral issues we should be teaching our youth today.
Frank, I know you've never met Scott Pasola before today, but given the fact that he says he's a gay scoutmaster and is taking some public stands on that issue, is he protected by the ruling of the state Supreme Court, or is he in limbo because the case is on appeal? Does it apply to him?
Well, at the moment he's in limbo because the case is on appeal. Assuming, though, the U.S. Supreme Court affirms the New Jersey ruling, it's not absolutely clear that Scott's current position will be protected.
What's the difference?
Well, the difference is that the New Jersey Supreme Court was very careful in the Dale case to say that Dale was not advocating anything. It was merely a status. He was being expelled from the Scouts only because of his status. And it was inadvertent that it was even discovered that he was a gay Scout leader. He didn't bring it into Scouting. It leaves open the question if a Scout leader actually wants to sort of start advocating this right and make it a controversial issue within the Boy Scouts. I think it's an interesting issue, not clearly protected under the Dale decision.
Well, I'm not clearly advocating it within the Boy Scouts organization, at troop meetings, at council events as such. We're a private organization, a nonprofit organization that's going through the public. The Boy Scouts of America do not allow Scouts to wear uniforms outside of Scouting events. This is clearly not a Scouting event, and we're not advocating the issue of gays and Scouting within the Scouting organization, except for at the very national level with the president of the Scouting organization. I know I personally have never brought the gay Scouting issue into my troop. It was asked once at a committee meeting. I had answered honestly and truthfully like Boy Scouts should, and it has never been brought up again. I feel that if you do advocate homosexuality or heterosexuality for that matter in the environment of 10, 11, 12, 14-year-old boys, then that clearly should not be brought up.
Frank, why should, let's get to the basis of this thing, why shouldn't the First Amendment protections cited by the Boy Scouts hold?
Because the New Jersey Supreme Court was very careful in this issue. It's a very careful opinion written by Chief Justice Porras, that the Boy Scouts have never really made sex or sexuality part of their creed. It's not like an association committed to oppose homosexuality or to being sexually straight and not gay.
The example we hear is the Ku Klux Klan. Since the Klan exists to further discrimination, if they discriminate, it's legal.
That's correct. They could get away, even if they were a public accommodation, they could still probably keep others out.
Let me stay on point. Suppose someone started an organization saying that gays should not be allowed to participate in American public life. Crazy idea, but one that would presumably be, the idea is protected.
Right.
Could they then say you can't join the organization if you're gay?
Absolutely.
And why is that acceptable?
Even if they invited every straight person to join them, they could probably exclude gays because it is part of their essence, their expressive activity. In the case the Boy Scouts rely on was the Boston Parade case, which excluded a gay group from marching with banners in the parade. And the U.S. Supreme Court said, well, gays can march in the parade, but they can't have their own expressive views in opposition to the sponsors' expressive views. That became a free speech issue. The New Jersey Supreme Court carefully distinguished Dale from that case because there was no banner. He's not advocating anything. He's merely being discriminated on because of his status, and that was the big difference.
Let us ask you. You've already made one prediction that we're not so sure you're correct on. Right. Let's ask you on this one. Coming up again before a relatively conservative court, what do you anticipate?
I'm not going to go out on a limb twice in one program. I think this is a close case. I think it's a hard case. I think Chief Justice Ports wrote a very careful opinion. I think it was very persuasive, and maybe it will stand up, again, even in a very conservative court. Maybe. Not making any guarantees.
Sandy, we're going to have to come back and check on whether Frank Askin is accurate after the Supreme Court has ruled. Frank, it's good to have you with us. Scott, thanks for joining us. Sandy, it's always good to work together with you. That's it for this edition of Due Process. But we'll be back next week with more cutting-edge issues of law and social justice. Until then, for Sandy King and all of us at Due Process, I'm Raymond Brown. See you next week.
Probably the criminals have too many rights in this country. And I think we must put some stop to some of those rights.
I think that there's no reason that we should get rid of it. I think honesty, telling people their rights can never hurt anyone.
I think people have a right to remain silent until they get a lawyer, until they have a time to think about what's going on. So I think that right needs to be protected.
If you break the law and you get arrested, you don't have the right to remain silent. You have the right to tell me what you did and why you did it.
Like it says, anything you say will incriminate you. And being that most of us do not know the law, and lawyers do, and we trust the system to where it'll work for us.
I don't think it should be getting rid of, because I think people all have a right to know their rights before they're arrested.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual,